statutory demand is a powerful debt recovery tool available under the Corporations Act 2001. It is a formal written demand issued by a creditor to a company for a debt of $4,000 or more that is due and payable. The demand must be in the prescribed Form 509H, state the amount owed, and if the debt is not a judgment debt, be accompanied by a supporting affidavit verifying the debt. It must be properly served, usually at the company's registered office. Once served, the company has 21 days to either pay the debt, reach an arrangement to the creditor's reasonable satisfaction, or apply to the court to have the demand set aside. If the company fails to do any of these things within the 21-day period, it is presumed to be insolvent under 459C of the Corporations Act. This presumption allows the creditor to apply to the court for orders to wind up the company. A company can apply to set aside a statutory demand under Section 459G if there is a genuine dispute about the existence or the amount of the debt, if the company has an offsetting claim, or if there is a defect in the demand that would cause substantial injustice. The 21-day time limit to file and serve such an application is strict and cannot be extended. For creditors, a statutory demand can be a strategic and efficient way to recover debts or commence insolvency proceedings. For companies, prompt action is crucial. Failure to respond correctly can result in the company being wound up. Reach out to our experienced team for a free 30-minute consultation with one of our statutory demand professionals and let us help protect your rights.